Hello and welcome to our today's lecture on nervous shock in law of torts. What is nervous shock? Nervous shock has no definite definition. It is known as any recognizable psychiatric illness caused by breach of duty by the defendant. It is not ordinary grief, sorrow or anxiety which occurs in normal incidents in life. This branch of law is comparatively recent. When person got physical injury not by an impact, for example by a stick, bullet or sword, but merely by a nervous shock through what he has seen or heard. Before a claimant can recover damages for the nervous shock which he suffered as a result of the defendant's negligence, he must prove all of these elements of the tort of negligence. Number 1. The existence of a duty of care, that is, the duty on the part of the defendant not to inflict nervous shock upon the claimant. Number 2. A breach of that duty, that is, the defendant's actions or omissions in the circumstances fell below what would be expected from a reasonable person in the circumstances. Number 3. A causal link between the breach and the psychiatric illness, that is, the nervous shock was the direct consequence of the defendant's breach of duty. Number 4. The nervous shock was not too remote a consequence of the breach. For fear of spurious actions and unlimited liability of the defendant to all those who may suffer nervous shock in one form or other, the English courts have developed a number of control mechanisms or limitations of liability for nervous shock. These control mechanisms usually aim at limiting the scope of the defendant's duty of care not to cause nervous shock, as well as at causation and remoteness. As far back as 1888, the Judicial Committee of the Privy Council in Victorian Railway Commissioner versus Coultus, 1888, did not recognize injury caused by a shock sustained through the medium of eye or ear without direct contact. They thought that an action could not be sustained unless there was a physical impact or something akin to it. Not long after the stated decision, we however find that injury caused by nervous shock without there being any physical impact has been recognized. I quote, "The crude view that the law should take cognizance only of a physical injury resulting from actual impact has been discarded, and it is now well recognized that action will lie for injury by shock sustained through the medium of the eye or the ear without direct contact, held in Boer versus Young, 1943. In 1897, Wilkinson versus Downton, 1897, the defendant was held liable when the plaintiff suffered nervous shock and got seriously ill on being told falsely by way of practical joke by defendant that her husband had broken both the legs in an accident. In Doyle versus White and Sons, 1901, as well, an action for nervous shock resulting in physical injuries was recognized. The defendant's servant negligently drove a horse van into a public house, and the plaintiff, a pregnant woman who was standing there behind the bar, although not physically injured, suffered nervous shock, as a result of which she got seriously ill and gave premature birth to a stillborn child. The defendants were held liable. Kennedy J. although recognized an action for nervous shock, but he imposed a very great limitation where he held that for such an action the shock must be such as arises from reasonable fear of immediate personal injury to oneself. This meant that if by the negligence of, say, X, danger is created for A can bring an action if he suffers nervous shock. If on the other hand, seeing or hearing of the danger to B, another person, say A, suffers nervous shock, A cannot sue X. If by a negligent act towards B, nervous shock to A can be foreseen, A is well within the area where injury through nervous shock could be caused to him, and there seemed to be no justification for debarring A from bringing an action. A person may suffer nervous shock even though he himself is not within the area of physical injury to himself. The case of Hambrook versus Stokes brothers, 1951, recognized an action when danger of physical injury to B caused a nervous shock to A. The facts of the case are: soon after having parted with her children in a narrow street, she was frightened about the safety of her children. When told by some bystander that a child answering the description of one of her children had been injured, she suffered nervous shock which resulted in her death. In an action against the defendants who had negligently left the lorry unattended there, they were held liable even though the lady suffering the nervous shock was not herself within the area of physical injury. Expressly disapproving the stated limitation imposed by Kennedy in Doyle versus White, Atkin L.J. said, and I quote, "Personally, I see no reason for excluding the bystander in the highway who receives injury in the same way from apprehension of or the actual sight of injury to a third party. There may well be cases where the sight of suffering will directly and immediately physically shock the most indurate heart, and if the suffering of another be the result of an act wrongful to the spectator, I do not see why the wrongdoer should escape." In Doyle versus Cormier-Laird and Company, 1951, the plaintiff, the driver of a crane, suffered nervous shock when he saw that by breaking off a rope of the crane, its load fell into the hold of ship where some men were at work. The rope had broken due to the negligence of the defendants, and they were held liable to the plaintiff. In Owens versus Liverpool Corporation, 1939, the Court of Appeal allowed the plaintiff's action for nervous shock which was caused not because of any peril to human life, but by the imperilment of a coffin containing the corpse of a near relative. Peculiar susceptibility of the mourners at that time was held to be no defense. Mackinnon L.J. idiosyncrasies of his victim that increase the likelihood or extent of damage to him. It is no answer to claim for a fractured skull that its owner had an unusually fragile one. Although, as has been stated, it is necessary that the plaintiff himself must be in the area of physical impact to bring for nervous shock, it is, however, necessary that the plaintiff must be so placed where injury through nervous shock can be foreseen. Where any kind of injury to the plaintiff cannot be foreseen by the defendant does not owe any duty of care to the plaintiff and will not be liable for the loss suffered by him. In Boer versus Young, 1943, the plaintiff, a fishwife, while getting out of a tram car, heard of an accident but could not see the same as she was about 50 feet away from the scene, and her view was obstructed by the tram car. In the accident which had occurred, a negligent motorcyclist had been killed. After the body of the motorcyclist had been removed, the fishwife happened to go to the scene of the accident and she saw the blood on the road. As a result of the same, she suffered nervous shock and gave birth to a stillborn child. She sued the personal representatives of the motorcyclist. The House of Lords held that the deceased could not be expected to foresee any injury to the plaintiff, and therefore he did not owe any duty of care to her, and as such his personal representatives could not be made liable. In King versus Phillips, 1953, the defendant's servant was negligently backing a taxicab into a boy on a tricycle. The boy's mother, who was in an upstairs window at a distance of about 70 to 80 yards, could only see the tricycle under the taxicab and heard the boy scream, but she could not see the boy. The boy and the tricycle got slightly damaged, but the mother suffered nervous shock. The mother was held to be wholly outside the area of reasonable apprehension, and the defendants were held not liable. According to Singleton, L.J., and I quote, "The driver owned a duty to the boy, but he knew nothing of the mother. She was not on the highway. He could not have known that she was at the window, nor was there any reason why he should anticipate that she would see his cab at all." The facts in this case do not appear to be much different from those in Hambrook versus Stokes brothers, where the mother suffering nervous shock because of fear of injury to her children could recover. For the purpose of an action for nervous shock, a person need not be in the area of physical injury to himself. It is enough that he is so placed that a shock could be caused to him by his seeing or hearing something. It therefore appears that the case of King versus Phillips requires reconsideration. Let's have a look at some recent case laws on nervous shock. In Sion versus Hampstead Health Authority, 1994, the Court of Appeal on 27th of May 1994 struck out as doomed to fail a claim by a father who suffered psychiatric injury through attending for some 2 weeks at the bedside of his 23-year-old son, who had been injured in a traffic accident and fatally deteriorated in hospital due to allegedly negligent medical treatment. The court took the view, relying solely on the pleadings and having regard principally to the psychiatric report that was served with the particulars of the claim, that there was no evidence of shock, no sudden apprehension by sight or sound of a horrifying event, but rather a continuous process that ran from the father's first arrival at the hospital to a death 2 weeks later, that was by then not unexpected, and on then to his realization after the inquest of the possibility of medical negligence. This seems odd. In the first place, does it make any sort of sense that there probably have been a good claim if the father had still been hoping for recovery when death occurred, and had therefore been shocked when there was a sudden fatal deterioration? Secondly, there do appear to have been discrete shocking type events during the 2-week period, such as a sudden, though not immediately fatal, deterioration, sudden respiratory difficulties, cardiac arrest, and transfer to the intensive care unit. A more imaginative judgment, in the best sense, was given in the Central London County Court by Judge White on February 4, 1994, in the case of Tredget and Tredget versus Bexley Health Authority. Although this was before the Court of Appeal judgment, it was after Brooke J. had struck out Mr. Sion's claim at first instance, and nothing that was said in the Court of Appeal invalidates Judge White's approach. In the first place, this case concerned claims for nervous shock sustained by both parents as a result of a traumatic and frightening delivery of their fatally injured child following allegedly negligent failure to go for an earlier caesarean section, and as a result of attending upon their son during his short life of some 2 days. The case was thus rather different from the usual attending by the bedside case. Judge White accepted, as did the Court of Appeal in the Sion case, these requisites for a successful claim. The plaintiff must show he or she has suffered an actual psychiatric illness caused by shock. That is, the sudden and direct appreciation by sight or sound of a horrifying event or events, rather than from stress, strain, grief, or sorrow, or from gradual or retrospective realization of events. That there was propinquity in time or space for the causative event or its immediate aftermath. That such injury was reasonably foreseeable, and that the relationship between plaintiff and defendant was sufficiently proximate. It is surprising that the health authorities sought to argue that there had been no element of shock in the events that the parents had experienced, and quite amazing that they should have chosen to contest the mother's claim on that basis. Fortunately, the judge sensibly declined to see the 2-day period as lacking the element of shock. He saw the traumatic birth in which the husband had been involved and which had been complicated by shoulder dystocia, an obstetric emergency, and the delivery of a clearly traumatized baby and the ensuing harrowing hours of a single event, frightening and harrowing and satisfying the requisite of a sudden shock to the nervous system. He said, "Of course it was not in the nature of an immediate catastrophe which lasts only a few seconds, panic in a stadium or a motor accident, but one just as traumatic for those immediately involved as participants as each of the parents was. In my judgment, if this is a new step in the development of the law, it is not only within the principles that have been set out, but has its own inbuilt limits, being founded on the special relationship with all that follows of the parent with the child at the unique moment of birth." The judgment in Sion was given in May 1994, Some 3 months earlier, the Court of Appeal had similarly demonstrated its desire to restrict the ambit of this sort of claim, on this occasion in a case involving attendance at the hospital in the aftermath of a fatal traffic accident. The case was Taylorson versus Shieldness Produced Limited, 1994. The parents of a 14-year-old boy had gone immediately one morning to the hospital to which he, their only child, had been admitted after being crushed under a reversing vehicle. They did not see him at the hospital, but they followed the ambulance that transferred him to another hospital. The father glimpsing him in the ambulance, the mother seeing him briefly as he was being rushed into the intensive care unit on a trolley. They did not see him then for a few hours while he was being treated. The father saw him that evening when he had black eyes, blood on his face, and a tube attached to the top of his head to relieve pressure on the brain. The mother saw him the next day in a similar state. The boy remained unconscious for 2 days. Then the life support machine was switched off. The parents were with him throughout that time. The court said that the shocking events were not sufficiently proximate and the involvement of the parents did not come within the aftermath principle. It seems that the first conclusion was based on the lack of close contact in the first few hours and the second on the refusal of the court to adopt the reasoning in Janes versus Coffey and extend the aftermath period to include the 2 days waiting at the bedside of the dying child. Both these conclusions are suspect and appear to stem more from a desire on the part of the court to restrict the ambit of the nervous shock claim rather than on any convincing logical thought. In the first place, it is difficult to see why the trauma of the arrival at the hospital and what went on in the next hour or so in this case did not constitute a sufficiently proximate shocking aftermath, regardless of how close the parents actually came to the child. It's also hard to see why a protracted shocking period of time should not fulfill the criterion of a sudden assault on the nervous system. It is also to be noted that the court found that causation was not proved, in that they took the view that the real cause of the psychiatric injury to the parents was the loss of their child, and so the injury would have been sustained even if there had been no question of any participation in any aftermath. This is a difficult contention to defeat in such a case. One possible way to meet the argument is to ensure that the psychiatric report not only identifies a discrete shocking event or events coming within the immediate aftermath, which should be taken probably to mean an hour or so from the accident, to which the claimant was reasonably proximate, but it also states that the event or events materially contributed to the arising of the psychiatric injury. While the ambit of this type of claim remains hedged about what such unsatisfactory and illogical restrictions, it is advisable that the psychiatric report served with the pleading states not only the plaintiff has suffered an actual psychiatric injury which was caused or materially contributed to by his or her presence at and around the last hours and the death of the loved one, but also that the injury was largely caused by a sudden assault on the nervous system constituted by events A, B, C, the events to be specified by the report and to be events coming within the immediate aftermath of the accident or the injury. In this way, the expert medical evidence will support the requisite of a shock caused either by witnessing a sudden horrific event or by the sudden arising of shock inducing awareness in the mind of the plaintiff. House of Lords in McLoughlin versus OBrien, 1983. To shock caused by coming upon the aftermath of a horrific event, for example, coming to the hospital and finding your family lying injured after a traffic accident. Many of the different aspects of this sort of claim were clarified by the decision of the House of Lords in the Hillsborough Stadium case, Alcock versus Chief Constable of South Yorkshire, 1992. It was made clear that the witnessing cases needed to satisfy the tests of familial, temporal, and spatial proximity. A line was therefore drawn between close and not so close relatives, the familial test, between coming on the scene and coming several hours later to the mortuary, the temporal test, and between being at the scene and merely viewing it on television, the spatial test. A recent example of the spatial test not being satisfied is McLoughlin versus E. Caledonian 1994, where the Court of Appeal said that the plaintiff, though in a vessel nearby, had not been sufficiently proximate to or involved in the Piper Alpha disaster to qualify. Recent cases have attempted to come to grips with the context of nervous shock caused to a relative by attending the terminal hours of a loved one dying as a result of medical negligence. The question that immediately springs to mind is how the element of shock can be satisfied in such a case, assuming that there is no such shocking element as the relative finding the loved one dying or dead at home. In the Hillsborough case, Lord Atkin said, "Shock in the context of this cause of action involves the sudden appreciation by sight or sound of a horrifying event which violently agitates the mind. It has yet to include psychiatric illness caused by the accumulation over a period of time or more gradual assaults on the nervous system." In Jange versus Coffey 1984, the Australian judge Brennan J. said, "I understand shock in this context to mean the sudden sensory perception, that is, by seeing, hearing or touching of a person, thing or event, which is so distressing that the perception of the phenomenon affronts or insults the plaintiff's mind and causes a recognizable psychiatric illness." Not infrequently in the past, settlements have been achieved in respect of psychiatric injury caused to, for example, parents attending at the bedside of their dying child. But until recently, there had been no reported cases in point. Now there are 4, one of which went to appeal. In Taylor versus Somerset Health Authority 1993, All J rejected a claim by a widow who had come to the hospital after her husband had suffered a fatal heart attack at work due to earlier medical mismanagement. She had not believed that he had died, not even when she was so informed by a doctor. She then saw him lying peacefully behind curtains in the basement of the hospital. The judge said that this did not fulfill the test of temporal proximity. In other words, she was too late on the scene. He also said that there had to be an external traumatic event. However, in the Sion case, Peter Gibson, LJ, made it clear that an external horrific event was not a prerequisite, as the crucial element in this sort of claim was a sudden awareness, violently agitating the mind of what was occurring or what had occurred. It could, however, be argued that in the Taylor case, what was absent was the necessary element of horror or sudden shock. One has to remember that one cannot claim merely for psychiatric injury caused by the death of a loved one. However, the current position of the English courts has been criticized as leading to unfair results both in law and from the medical point of view. For example, it may be arbitrary that a mother who witnesses the death of her child with her own eyes can recover if she develops a mental illness, while one that hears of her child's death on the phone and suffers the same condition cannot. Reform has been widely advocated, and in 1998, the Law Commission has drafted a proposal suggesting that the requirements of proximity in time and space to the accident and the own unaided senses rule should be abolished. The Department for Constitutional Affairs rejected the recommended legislative reform in 2007, noting that the courts had adopted a more flexible approach and proposed to leave this area to the courts. In July 2009, the Ministry of Justice confirmed that it did not intend to proceed with the Law Commission's recommendations in this area. In the light of our discussion today, it becomes clear that nervous shock is not ordinary grief, sorrow, or anxiety which occurs in normal incidents in life. It is a recognizable psychiatric illness caused by breach of duty by the defendant. With this, we come to the end of our today's lecture on nervous shock in law of torts. Hope it was helpful for you. Thank you for watching and have a good day.